Start. It is urged that since the respondent did not take the suit to its logical conclusion, the trial court, notwithstanding the withdrawal of suit by the respondent, ought to have allowed the application of the petitioner. The provision of restitution applies when order is reversed. No order has been reversed in the present case. All that has happened is that on the application of the respondent for interim relief, this court merely directed to MCD to perform its statutory duty. This court did not make any inquiry as adjudication as to whether the construction was unauthorized or not, whether there was any encroachment or not. It is the MCD which informed this court that there was unauthorized temporary construction, and this court merely directed the MCD to perform its statutory duty. If it was the case of the petitioner that the construction which the respondent was alleging to be unauthorized was in fact sanctioned, that the MCD had no right to take any action with respect thereto, it was open to the petitioner to approach the appellate tribunal. The petitioners, however, in spite of the order of this court and the report by the MCD thereon, did not take any such action. Had the petitioner taken any such action, in that the tribunal constituted specifically for the said purpose would have decided whether the construction is legal and unauthorized or not. In the absence thereof, the trial court could not be expected to adjudicate the application aforesaid of the petitioners, notwithstanding withdrawal of the suit. Para. It is to be presumed that the action of demolition taken by the respondent, even if pursuant to the order in the suit, qua the shop of the petitioner, was in accordance with law. If the same is not in accordance with law, and if the respondent has exceeded its authority, again the petitioner have remedies available to them in law. The petitioners, however, cannot be permitted by an order of the trial court and of this order to install shutter or to restore the premises to the same condition in which it was prior to the demolition action, merely for the reason of withdrawal of the suit. There is no sanction plan before this court for this court to be satisfied as to what is sanctioned construction on the property only if the action plan was available could this court, in the exercise of equitable jurisdiction, have considered the request of the petitioner. However, in the absence of the same, allowing the petitioner to restore the premises or to install shutter would tantamount to this court giving blanket permission to the petitioner to carry out any construction or encroachment on the property. No site plan has been filed to satisfy the conscience of this court. Of course, the counsel for the petitioner states that petitioners are tenants in the shop and cannot be expected to have the sanction plan, but the same would still not entitle the particular to any directions as claimed. If it is the case of the petitioner that the respondent has caused any loss to the petitioner, again the petitioner have to take remedies available in law to them in this regard, and the same could not have been decided by way of the application in the suit which has withdrawn the suit merely because the petitioner had filed an application for taking similar action was taken with respect to the shop of the petitioners. Stop.